Repossessions can be legal. They can be if everything is done exactly to a T. But I would say, in my experience, well over half of repossessions are illegal. Not because you can't take the car because someone didn't pay on the loan, because they've done it the wrong way. That's what separates you from the rest of the people in this space, is you understand the real strength behind how you attack these. So here's what we do, Dave. Again, we're not going to say that every repossession is illegal and it's theft, all that nonsense. No. What we're going to do is go back to the beginning. So there are several laws that forecast and require every party in this instance, whether that's the tow truck company, the bank company, the collection company, the credit reporting agencies, they all have to follow such specific sets of requirements and steps. And if they miss just one, that repossession is illegal. And then I can get it removed from a credit report and compensation on top. So let me just give you some examples of what that is. Repos are very easy to get rid of off credit reports because they're almost all done illegally. And here's why. Before they repossess your car, they have to send you a letter. That letter has to have very specific things in it. Almost all of them don't. So if they don't send you that letter, the repo is illegal. I can get it removed from a credit report. If they send that letter and it's missing stuff, then I can get it removed. If they send that letter and it doesn't give you the right to come get your personal belongings and tell you where, it's just all these things that repossession companies have to do that they don't. So that's number one. Number two, there's a second letter they have to send out. After they repossess the car, they have to send you a letter that says, we have the car, here's where it is, here's how much money you owe, and here's how to get your stuff out. If they don't send that letter, the whole thing's illegal. We can throw it out and get compensation. If they miss one little thing in that letter, that's only letter two. Then there's a third letter that's required to be sent. That's after an auction takes place. Dave, Mike, I mean, how many companies do you think even send all three of these letters to begin with?
I don't think they sent the first letter.
Yeah, right. Not a lot of them. And so it's not even just the existence of these letters, knowing to look for them, knowing what to look for when you find them. Is there's probably 100 different avenues to say we can attack a repossession or even a deficiency balance. So let's say it's not even just a repossession. It's just this company, now they're suing for a deficiency after a car was repossessed and sold at auction. There are a million different ways with these letters, with the amounts. Another thing too, this is a phrase you might hear. Repossessions have to be lawful and they cannot breach the peace. So what does that mean? You can't argue with someone. You can't, in the middle of a fight, take a car. You can't go behind a garage. You can't go behind a gate. You can't even go within a gated community. Let's say you're a tow truck and you're at a gated community and someone's in front of you, opens up that gate. If you follow them through, you have trespassed. You didn't have the right to be in that property. So then if you tow a car from that community, that's an illegal towing because you didn't have the right to be on that property. So that's another way. There are just so many avenues to attack the fundamental principles that underlie these actions, and they're all based upon laws. And if you don't know the laws, you don't know what to look for. So again, repossessions, I love seeing repossessions on credit reports, not because I love to, revel in someone's hardship, because I know that's someone I can likely help, because the parties that are on the other side, they're just motivated by profit and quickness, right? They want to take this car, sell it. They don't want to give you your rights, tell you your rights. And they certainly don't often follow the law, again, to a T, because the minute they step out of line, it gives us the strength to say, you must delete it. And if it doesn't, then we sue.
So how long, like one of the questions was, what can I do if I'm being sued?
Excellent question. So first of all, go back to something that Mike said. I'm not your lawyer. None of this is direct legal advice to any specific case. So if someone's been sued listening to this, I'm not telling you exactly what to do in your case, and there's no attorney-client relationship. But there are lots of things you can do. Number one, if you take nothing else from this, don't just put your head in the sand. That's the worst thing you can do. That's the worst thing your clients can do, your consumers can do, because that is what they want. Remember, this all ties back to this whole economic idea of they don't want you to fight. They make their profits by you not fighting. On the 999 people out of 1,000 that don't fight, But if you do fight, they often don't like getting hit back and they will roll over. So number one is just don't put your head in the sand. Don't act like it didn't exist. Don't just pull the covers over your head and hope it's going to go away, because it's not. It's going to end up in a judgment, and a judgment is death. We do not want things to go to judgment. Judgments are much harder to get rid of. I'm sure you all know that. Trying to get rid of judgments on credit reports or judgment amounts. Once it's a judgment, it is so much harder, because that becomes something that these companies can go back to court forever to collect. Literally, judgments never die. Not like a debt that has a 5-year statute of limitations. Judgments in most states can literally just last forever. So we want to avoid that. So don't ignore it. So let's talk about what you can do. A couple of things. One is compare information on that lawsuit to your credit reports. It is so frequent that we see a company suing for one amount and credit reporting another. I love seeing that, because I'm going to win, because one of them has to be false. Either you're suing for the wrong amount and then you lose your lawsuit and I sue you under the FDCPA, or you're credit reporting the wrong amount and I sue you under the FCRA. So you're damned if you do, damned if you don't. That's one of the best tools to look for, is just look at the simple amount. Is it different between what they're suing for and what's on the credit report? Same thing when you're comparing it to debt collection letters. You know, these companies don't like to sue because it costs them money. You know, us lawyers, we cost money, right? So they have their own sharp lawyers that they hire, you know, that are bottom feeders on the other side, and that costs them money. So they always call and send letters first, right? We all know that. So compare those amounts, you know, look at what's being asserted in a debt collection letter and then what's being sued. You know, that's often wrong. The other thing too is, Dave, here's a secret. If it's a junk debt buyer, if it's the Midlands of the world, the LVNVs, you know, the PRAs, remember, because they paid so little for that debt, you have so much negotiating room with these companies, not only to just settle the debt if you don't have the will to fight or if it's not going to be a winning case, but remember, their margins are so low that what they paid for it, you can negotiate those debts down so much. That's always better than just putting your head in the sand. And again, I just go back to don't get a default. Then just be proactive. One, call me if you have to. Call Dave and Mike, because my goal is to help as many consumers as I can. Even if you're being sued in Alaska, I can't help you there. I want to put you in contact with someone that can, though, because we want to fight. We want to take that 1 out of 1,000 and make it a lot more consumers are fighting back, because we can win these things. When they sue, the whole thing shifts, Dave. When someone calls you up and says you owe debt or sends you a letter, who knows, right? Pay them or not. But once they sue, they're in a court of law. Now they have to prove beyond the shadow of a doubt, you know, by a preponderance of the evidence that you owe the debt. That's a whole different animal. So once it gets to suit, there are, again, strategies. We want to use the laws, look at what's being credit reported, how they've collected the debt, the amounts, you know, the dates, everything with a fine-tooth comb, because there are ways to win these lawsuits. Just like there are ways to get repossessions off a credit report, even if there was a repossession. If someone defaulted on this debt, it doesn't mean you lose automatically. You should not just get a default. But we want to fight back, especially if it's a junk debt buyer. First party debts are harder, Dave. I just want to be transparent. If it's Amex suing or a credit union suing, it's always harder, because they're in privity of contract. You know, they've probably got the signed applications still. They probably have all the payment records. When it gets sold over and over again, by the time it gets to Midland and LVNV and all those, you know how hard it is for them to find the paperwork to really prove their case. So if someone's getting sued, fight back. Reach out to Dave and Mike, reach out to me, reach out to a lawyer in your state. There are ways to win these cases and then to fight back, because what I love to do, my favorite thing in the world, is when one of these junk debt buyers sues my client, they're going in all, you know, bravado. They think this consumer is going to roll over and get a default. But then I show up, we kick their butt, we win, and then I sue them. Not only we won the lawsuit, but now I get to sue them because they've broken the law somehow. And it almost is always the case that if we're able to win a case, it's because they filed something wrong. They were missing information. They, like I said before, one number didn't match the other. There are many outlets that we can use to win when someone's being sued, but then also to sue back. And that's fun, because then instead of them getting money from you, it's the opposite. They're paying me and they're paying you.